Question of the day: if you're working with a client that is selling a property that's titled as a trust or an LLC or an S corporation, or maybe you're representing a buyer, who's authorized to sign for that entity, and what's the signature block look like? That's what we're going to discuss in this video. Hey everyone, if we're meeting for the first time, my name is Paul Vojchehoske and welcome to the Real Estate Classroom YouTube channel. It's just a place where real estate professionals can get tools and tips to stay out of real estate jail. And hey, real quick, if you would, please click on that little subscribe button and that little notification bell next to the subscribe button, and give this video a thumbs up or even a thumbs down. Either way, I don't care. It is all traffic for this channel. All right, we're going to deal with who is authorized to sign first. Now, as a real estate professional, you do have a duty to reasonably investigate, number one, who owns the property. And typically when you get a phone call from a potential seller, we do a records check on maybe the treasurer's office website or the assessor's office, and it will list who the owner of record is. It's typically what we do as agents. Question is, what happens if that property is titled in again, a corporation, an LLC, a trust, or maybe the person on the phone identified themselves as that's going to be a power of attorney, those type of things. We have, at that point, a reasonable duty to ensure who has the signature authority here, because not every entity is the same. So as an agent, it's a good idea to get a copy of the articles of organization for that corporation, or the bylaws for the LLC, or a copy of the trust, or a copy of the POA. We don't necessarily need the originals, but we just need, for our purposes, to get things listed, copies. And here's why this is important. So for example, if it's an LLC, which is very common, maybe there's 3 members of this LLC. The LLC may have been organized in a way where there's only one member that has the right to sign on behalf of the other 2. So you would only need to have that person's signature. But absence that authority, then all 3 members would have to sign all the documents and disclosures. So that's what we're looking for. You never ever take anyone's word for it. We trust but verify, and the way we verify is through getting those documents and keep them, just a copy of them, and put them into the file. All right, so let's look at the actual signature blocks. The first one we're going to talk about is an LLC. So here we have an example of an LLC where we have Bruce Wayne and Diana Prince, who have created an LLC, and they're either going to be buying or selling a property that's going to be in that LLC. And so on the right-hand side is how the signature block should look. We have to identify Justice Society Investments LLC, a Nebraska limited liability company. If you're going to be in Colorado, Utah, wherever, the same principle would apply. And then in this case, we've identified the 2 members. So in this case, this is telling us that there wasn't one member that had the signature authority. So Bruce and Diana both have to sign any documents, any contracts, any disclosures. That's how the signature block on a purchase agreement, a listing agreement, whatever would look like. Let's go to the next one, a personal representative. This is where we're dealing with an estate situation. So in our example here, Lois Lane is the personal representative of the estate of Clark Kent. So let's say Clark Kent owned a house and Lois Lane is now selling it because she has been designated either through a will or through the courts that she's the personal representative. So here's how the signature blocks would look like. The estate of Clark Kent, and then Lois Lane would sign it, and her title is a personal representative. All right, we're going to deal with trust. There's 2 different types of signatures here. We got a seller trust and a buyer's trust. So in this case here, Avalon Stark, this trust is selling some property, and here's how the signature block would look. The Anthony Edward Stark Revocable Living Trust dated May 2nd, 2008. I know it's long, but that would be required to be indicated on all contracts, disclosures, and deed sets. And then Avalon Stark would sign, and then her title is successor trustee. Now on the buyer trust side, for a buyer's trust, in this case here, we would have on the signature block Captain Marvel Revocable Living Trust dated March 6, 2019. Now, where do we get these dates from? Well, we get them from the trust documents that we've got from our client. And then it says, as amended and restated, and her successor trustees. Now, this is for a buyer's trust here. All right, and then Carol would sign it, and her title is the successor trustee. That's how it would look on this under this scenario. Power of attorney. I'm going to spend a little bit more time on the power of attorney because a POA is very common in our industry. So here's the example. Charlie Day owns this piece of property, and through a power of attorney has designated D. Reynolds as the power of attorney, or what we call attorney in fact. So D. Reynolds is his attorney in fact. That's just the legal term for D. Reynolds. So D is going to sign all the documents, contracts, and disclosures and deed sets. All right? Two things I want to note here. Number one is, which name is actually signed? So does D sign Charlie Day's name, actually Charlie Day, or is it D. Reynolds' signature? Well, I will tell you that I've had this conversation with a couple of different attorneys, and they also say, well, technically, D. Reynolds should sign Charlie Day's name, all right, because you're doing it by. However, I will tell you from a reality perspective, it depends on the title escrow company you're working with. You would think it'd be universal, but it's not. So you need to have the conversation with the title company. And the title company is going to tell you how to do that. Because in the end, it's all about getting insurable title. And it's going to be the title company that's on the hook should there be a cloud on the title after closing. So we're going to do it according to their instructions. So if the title company says we want D. Reynolds' signature, then do it that way. I would tell you for listing purposes, you probably would start with Charlie Day. That's if I'm D. Reynolds, I'm gonna sign Charlie Day's name, and then of course we have the by D. Reynolds, his attorney in fact. If the title company that's going to close the deal after we get a purchase agreement wants it changed, then we'll change it. But that's my recommendation to you. The other thing, part two of this, it's kind of unique in many states to the POA specifically. Please have the conversation with your client. That's the POA saying, here's the deal. For me, I need, as the real estate agent, I'm okay just getting the copy. However, the title escrow company that's going to eventually do the closing is going to need the original power of attorney because they're going to have to record the power of attorney, the original power of attorney, with the deed set. So have that conversation with them ahead of time because a lot of times the POAs are very reluctant to give up the original. So educate them ahead of time. What we don't want is a cold call from the title escrow company saying, we need your original, and D's going, well, wait a minute, who are you and why? So we've had this conversation ahead of time. Please do that. It just makes the deals a whole lot simpler. The same can be said for trust and corporations and LLCs. Please let them know as well that the title company is going to need the original. The reason I point out the POA is people that own trust and they have LLCs and those type of things, they kind of already, most of them already know the game if they've been buying and selling real estate in that trust or LLC. It's the POA that's really a novice, that don't really know anything about real estate. They're the ones that really need the education ahead of time. All right. The next one is a corporation. It's very uncommon to have that somebody's buying real estate in corporations, although in the farm community, there was a time years ago when that was the recommendation of the CPA community to buy farms and corporations, so you might see it there. Very, very uncommon with houses and those type of things, but it still may be there. So in our example here, we have Andy's Princess Corporation, a Nebraska corporation. The signature block would be Andy's Princess Shoes Corporation, a Nebraska corporation, and then Andy Ellaway signs it, and his title is president. So that's how a signature block on that contract or that deed set or the disclosures would look like for a corporation. That's all I got in this video. Thank you very much. I do appreciate those of you that contacted me and asked me to do this video on this topic. Please, before you leave, do me a favor. If you would please leave comments. Comments are very important. If I missed something, which I probably did, I'd love to have your input. If you have a question, put it down in the comments sections. Also, like the video. Don't forget to subscribe. Hit that notification bell. And please share this with others. Until next week, when it's a new video, new topic. I think next week I'm going to do escalation clauses. I think that's what's up next. Have a great week and get out there and sell something.